afternoon, everyone.
Afternoon, Your Honor.
How is everyone?
Fine, thanks.
Go ahead, have a seat, sir. We got a podium today, huh?
Do you need order to use it, Your Honor?
No. Some people like it, some people don't.
Yes, ma'am, thank you.
All right. Is everyone ready?
Yes, Your Honor.
I'll go on the record.
Yes,
Mr.
ma'am.
DeBoer.
Yes.
I'll have everyone identify themselves for the court reporter, and then I have a housekeeping matter I want to take care of, okay? All right, so we have in re COVID-19 litigation, case number 2020 MR 589. If the parties would please introduce themselves for the court reporter, we'll start with the Attorney General's office.
Good afternoon, Your Honor. Thomas Pritzker for the Attorney General on behalf of the Governor. In the cases we're presenting today, I think it's the Governor only.
Okay.
Good afternoon, Your Honor. Darren Kincaid, that's Kinkead, also from the Attorney General's office, and also appearing on behalf of the Governor.
Thank you.
Thank you.
Your Honor, Thomas DeBoer here on behalf of a variety of plaintiffs in this matter, Mr. Bailey being one of them, in addition to Ms. Riley Cray et al. As it relates to the other, we call county cases.
Okay.
Darren Bailey.
Hello, Mr. Bailey. Okay. I wanted to let both parties know that, and I printed out here, I have received communications. I just want full transparency. I'm on the ballot this year. So through my Facebook page, my campaign Facebook page, my campaign email, and I guess it's Messenger through Facebook. I'm trying to get this right. I have received 3 communications from individuals. I copied and pasted them. I made a copy for each of you if you would like to read it. I have read them. I did not respond to them. Would you take that to them? They in no way influenced my decisions on these cases, but I wanted to make all the parties aware of them. And I'll give you a chance to read them, and then we can address if there is any concerns. Oh, I'm sorry. I was waiting for you to say something.
We're waiting for you, ma'am.
I'm sorry. Any concerns by any side? I doubt there'd be any from Mr. DeVore, but there could be.
You never know with Mr. DeWolf, but no.
Okay.
Absolutely no concerns whatsoever, Your Honor.
All right. So if I am correct, we are here today on the motion to vacate, the motion to add count 5, and then the motion to dismiss the, what we have referred to as the county cases. Am I correct?
Yes,
That's
ma'am.
correct, Your
All
Honor.
right. So do we want to take up the motion to vacate first?
I actually have a preliminary matter.
Okay.
First, Your Honor.
All right.
I don't know if it's, well, I'll just go forward with it. As the court noted, we have 3 motions scheduled for hearing today. the governor's motion to vacate the July 2 summary judgment order in the Bailey matter, Mr. Bailey's motion to add count 5 to his complaint in what was the Clay County matter, and the governor's motion to dismiss several of the consolidated cases, what the court has just referred to as the county cases. It's only one of those motions, Your Honor, the motion to vacate, is fully briefed. And that is important in light of the court's September 22, 2020 order in this matter, the amended briefing schedule order. In that order, specifically paragraph 3, the court ordered and noted as follows: in the Clay County case number 2020-CH06, Plaintiff Bailey shall file his reply in further support of his motion to add count 5 by September 21, 2020. In paragraph 4, the court ordered plaintiffs in Sangamon County case 20-MR589 and related consolidated cases, and then each of which is listed, collectively the consolidated Craig actions, shall file their response to the governor's motion to dismiss by September 21, 2020. Those response briefs in the consolidated cases and the reply brief in the Clay County case were not filed on September 21, 2020. In that same order, the court noted the above filing deadlines, and this is from paragraph 7, shall be strictly enforced. Extensions of time shall not be granted absent good cause shown and upon motion filed before the deadline. And then in paragraph 9, the court first noted that the October 14, 2020 hearing on these pending motions shall proceed as scheduled, and then provided as follows, quote, any party that has not filed its responses or replies in accordance with the schedule set by the court shall not be permitted to offer an oral response or reply at the hearing. Period, close quote. The order could not be more clear, and maybe there's no intent by Mr. DeVore to offer oral response to the motion to dismiss or any sort of reply in further support of this motion, of Mr. Bailey's motion to amend. But I just wanted to make sure the ground rules were clear before we started the hearing.
Well, I did notice that before the hearing today, and I wanted to inquire because I went back and I looked at my emails. Even though this order is dated the 22nd, it was received by me on the 21st at 3:58 p.m. And correct me if I'm wrong, I want the parties to refresh my recollection. We had a phone conference, I think, to get these deadlines. Is that correct, Counselor?
That's correct, Your Honor. We had a phone conference on September 17, 2020, in which the court considered the governor's motion to revise and enforce briefing schedule that had been filed on September 16, 2020.
Okay. And then we agreed on these deadlines, and then the parties were to submit a proposed order after you guys had agreed upon it, and then it was sent to me for signature and filing with the clerk. Is that correct?
You asked me to submit a proposed order, which I did. I believe my colleague, Gretchen Alfrich.
Gretchen did, that's correct, yes.
With, of course, copy to all counsel of record. That proposed order, designated as such, was emailed to the court.
And
I can give you the date, Your Honor. It was 10 o'clock in the morning on September 21, 2020. Ms. Helfrich wrote a short email to you. Quote, attaches a proposed order granting the governor's motion to revise and enforce briefing schedule, period. If you have any problems with the document, please let me know. She sent it to you in Word format. And of course, a copy of that to both Mr. DeVore and his colleague. then the following day, the court entered the order, although,
Oh, I'm sorry, I replied at 3:58, so you are correct at the time sent. I'm sorry. It shows that I replied at 3:58. Go ahead.
and of course, that all came about, Your Honor, as a result of the governor's motion to revise the briefing schedule and enforce briefing schedule. And I think it's important to recall what exactly was requested and the reasoning for the motion in the first place by the governor. And I'm reading from paragraph 6 of that motion, where the governor states, quote, "Granting the governor's requested relief will avert any need to postpone the October 14, 2020 hearing, delaying resolution of the cases, close paren, and will prevent the hearing from becoming argument by ambush, defeating the court's purpose in setting a briefing schedule ahead of oral arguments, period, close quote." And then we had our phone hearing on that motion, and the order was thereafter entered. So, the governor simply requests that the court's order be followed. And the motion to vacate be heard. It's fully briefed. With regard to the motion to dismiss and the motion to add count 5, no argument should be allowed from Mr. Bailey. The governor will proceed however the court wants with regard to those motions. We can make a full presentation, we can answer any questions that the court might have, or we can rest on the briefs, whatever the court desires. But the simple request is to enforce the order as written. It could not be more clear. The reason for the order could not be more clear. And if the order is not enforced, we're in a situation that we will have exactly defeating the reason for the order. We'll have oral argument by ambush. That's the request, Your Honor. Thank you.
Thank you.
Absolutely, Your Honor.
I will note, just before you tell me everything, that you replied that evening. I received an email from you at 9:25 that says that you will argue the governor's motion to dismiss the county cases as well as the objection to leave to amend Darren Bailey's cause to add count 5 in open court. Argument in court will better serve my clients than filing a written response.
Correct.
Okay.
Well, the court took most of what I was getting ready to say. Isn't it convenient, Your Honor, that my colleague is guilty of exactly what he just tried to accuse my client of? Ambush 5 minutes before the hearing is getting ready to start. We didn't lie in wait. We acknowledged within the time frame that we would rely upon the pleadings and argue the pleadings as they're presented. I'm not here going to offer, as they did in their motion, 30 or 40 news articles against what they have argued. I'm not here to do that. I'm here to argue what we have pled, what they responded in their motion to dismiss. It happens all the time, Your Honor, in courtrooms across this state and this nation, where you don't have to file a response to a motion to dismiss, you just come and argue. And again, we did nothing to mislead anyone or to suggest we were trying to ambush anybody. We gave you that response in time, and for that reason, Your Honor, we're merely here asking to argue on behalf of the pleadings as they've been presented to the court that dismissal is not warranted. Thank you.
Mr. DeVore, did you read that proposed order when it was sent on the 21st?
Absolutely. I read the proposed order to depart the dates. Absolutely. I can recall when we had that conversation, Your Honor, when we were on the phone, at no point in time did that conversation. If the court, I don't know if it was recorded or not, the court can recall. We didn't talk about if a filing wasn't made that somebody can't argue in court. Is that the last paragraph on that order?
Yeah.
Yeah, I read the dates, absolutely, and I knew what those dates were. But for what it's worth to the court, did I see a paragraph that says that? No, because to be honest with you, I've never heard of that in all my years as an attorney, that if you don't file a legal brief, that you can't at least argue the documents that are in front of the court.
What I recall is discussing paragraph 7, that the deadline should be strictly enforced, and then I wanted to put absent good cause shown, because to leave that loophole, I guess, in there.
I specifically remember that conversation, that that the governor's office did not want to be getting filings the day before the hearing that would cause a delay of this hearing. They were really concerned about having this hearing today, and that has not been foreclosed, ma'am.
Oh.
Can I respond, Your Honor?
Oh, I'm sorry, yes, please.
Thank you.
On the issue of people walking to courtrooms all over the state and just arguing the motion, well, that's fine, or it's true. But parties are obligated to know what's in the court's orders. And while it wasn't said, there's this suggestion that we snuck it in. It was discussed in the phone hearing, as well it should have been. Again, paragraph 6 from the motion. Granting the governor's requested relief will avert any need to postpone the October 14 hearing and will prevent the hearing from becoming argument by ambush. That was the whole point of the motion. The motion cites the authority. This is from the Parkway Bank case in our motion filed before the court on September the 16th. Quote, oral argument is a privilege, not a right, and is accorded to the parties by the court in its discretion, period, close quote. This court heard the motion, discussed it with the parties, and granted the motion and entered an order that could not be more clear. The briefs were not filed. Why? I don't know. I have my suspicions, but I don't know. But your order provided for what exactly would happen in that eventuality. What the order provides in that eventuality is that there is no oral argument by Mr. Bailey. That is the clear and unequivocal order of the court. And for Mr. DeVore to suggest that this is some kind of ambush, and isn't it convenient? It's not convenient at all, and it's certainly not an ambush. What happened is frankly what I feared would happen, and that's what drove me to file the motion at the outset. Because if you recall, at the time the motion was filed, Mr. Bailey had already missed a filing on the motion to vacate. And I specifically requested in the motion on the governor's behalf that Mr. Bailey be given relief from that he be allowed to file that response even though he missed the date. But going forward, we respectfully requested the court to strictly enforce the briefing schedule order, because I saw the train coming down the track. October 14 won't happen, we'll be into December, to November, then in December. It's time for these things to come to an end. And the court should enforce its own order. And it's not as if this order has some vagaries, some ambiguities. It could not be more clear. It was set out as requested relief in the motion. It was discussed at the hearing. It was contained within the draft order. And it's most importantly contained within the order entered by the court. Enforce your order, Your Honor. There should be no oral argument by Mr. Bailey on the motion to dismiss or the motion to amend. Thank you.
May I, Judge?
Yes.
The motion that they filed, where they, in paragraph 6, talk about an ambush, again, I'm repeating myself, but that's what's going on right now, was because of filing deadlines for filing written documents. Nowhere in that motion does it say anything in that about you can't argue the pleadings in front of the court as they exist. It's not in the motion. And I can stand here, and I think the court knows, and we had that conversation on the phone, it wasn't discussed either. There was nothing in there in that conversation that said, oh, if you don't file a reply or a response to this, you were foreclosed from even arguing the pleadings. That was not said, I assure you. Because if it was said, You would get an email from me shortly thereafter saying we're going to rely upon the pleadings and argument orally. Did they sneak it in at the last paragraph? Certainly did. My colleague doesn't send an email anytime to this court, or doesn't file anything in this court prior to right now suggesting to bar my clients from having oral argument because of that reason. They could have filed that on September 23rd, 24th, 25th to bar oral argument. This court could have addressed it then versus it and my clients being ambushed as a preliminary matter before this hearing, Judge. It's improper. There's no prejudice whatsoever to the governor having my clients argue against their motion to dismiss, where they're asking this court to dismiss the cause of action because their facts are indisputable and beyond reproach of this court. They don't want the court to hear that argument. It's got nothing to do with being ambushed. It's stating the obvious on the record. And again, they're trying to prejudice my clients by playing a game. I'm asking the court not to do it. Thank you.
File a motion to bar. There's no need for a motion to bar. The order is clear. The order does that. But beyond that, Your Honor, we again just heard from Mr. Lavore what the problem is. Plain and simple. It's inattentive. Inattentiveness. Mr. Lavore just told you, he just represented to the court, that there was nothing in our briefing schedule order, or motion, that suggested that if the written brief wasn't filed, that a party should be precluded from argument. This is the motion, and it's not as if it's a long motion, Judge. It's 3 pages long. This is from the motion filed September 16, 2020, paragraph 5. The governor also requests, then the request is made about the strict enforcement of the briefing schedule. And it continues, quote, and that any party that has not timely filed its response or replies be precluded from offering any oral response or reply at the October 14, 2020 hearing. Period. Close quote. That's an ambush. We could not have been more clear in the request. We could not have been more clear in why we made the request. And the court could not have been more clear in its order. Thank you, Judge.
Last thing, if I may, Judge. My colleague, being very clever, is playing with words. What is written there is a proposition to the court, and I certainly understand that I don't walk in this courtroom today with a stack of documents that tall and provide this court a response to their motion to dismiss that I could have filed. I understand that. Coming in here and taking their documents that they filed, their motion to dismiss, opening it up and making an argument to the court is not an ambush. That's not me having stacked up a whole reply brief or response brief and throwing it in front of them. And that would be an ambush. I'm not asking the court to do that. I'm really asking to take their documents and stand here in front of you and to offer to this court the argument as to why dismissal is not proper. I don't think their motion did that. I don't think their order does that. And I'd ask the court not to allow it. Thank you.
Well, I will tell you with regard to ad count 5, to me that's plain and simple. He filed a motion, he attached the proposed pleading. I don't think there's going to be much said there. Maybe I'm wrong, but I don't think there could be much ambush on that. He's already, I mean, I don't even know, when did you file that? You filed that a long time ago.
Months ago.
Yeah, the issue with count 5, Your Honor, is essentially the same with the motion to dismiss.
Their motion to dismiss was filed in August, Judge.
It's the opposition to count 5 is based on futility, which is the same reason that the motion to dismiss should be granted, because count 5 is the same theory of the county cases.
Right. I heard that. I want to proceed right now with the motion to vacate, then I want to take a recess And then I will rule on your motion, Mr. Verticchio, to have the briefing order strictly enforced, okay? I just want to think about it for a few minutes. The motion to vacate is fully briefed, everyone's ready to go. Let's do that right now.
I have a preliminary matter, Judge.
Oh,
Sorry. We filed a motion to stay proceedings, as the court is aware, based upon...
I did not know that until the Attorney General sent me the order.
That's fine. We'll take care of that. I'll take care of that right now. So there was a motion to stay filed requesting the court to stay these proceedings while there was a motion to reconsider pending in front of the Illinois Supreme Court. Illinois Supreme Court denied that request to reconsider. So I agree with Mr. Verticchio to the extent that that was something asking this court to do. It is now moot.
Okay.
My client does want me just to put on the record, again, no disrespect to this court whatsoever, but he just wants the record for future, potential appeals to be clear that he believes that the Illinois Supreme Court violated his substantive due process rights and not allowing him that change of judge. And so as long as the record is clear that he's proceeding with that having been made to the record, so he can raise that on future appeal, I just wanted that to be clear. But the motion to stay is moot.
Tell me again so I can get the right wording right in my docket entry. The motion to stay proceedings that was ruled on by the Supreme Court, but you disagree with the ruling by the Supreme Court.
The Supreme Court, again, ruled consolidating both 589
Right.
into being heard by Your Honor.
Right.
My client believes that's a violation of his due process rights that are given him under the statute.
Okay.
He believes there's potential not only state but federal due process implications. He just wants the record to preserve those issues for later dates is all. Other than that, we're prepared to proceed.
Okay. Okay, there is no offense taken whatsoever. That's his right to do that, so don't worry about that. I have noted it, it'll be in a docket entry, so it'll be on the record.
Thank you.
You're welcome. All right. Motion to vacate. Mr. Verticchio.
Thank you, Your Honor. The governor's motion to vacate the July 2, 2020 summary judgment order entered into Bailey matter, then pending in Clay County, is both straightforward and reliant upon established propositions of law. The Illinois Supreme Court in the Hartling versus Illinois Power case, Your Honor, that's cited by both parties, at page 154 says, quote, when a petition for removal has been filed in federal district court, the court continued, the state court loses jurisdiction to proceed further until the case is remanded. Close quote. The state court loses jurisdiction to proceed until the case is remanded. That's the first proposition. The second is that if a court lacks jurisdiction, any order entered by it is void for the lack of jurisdiction. We've cited several cases for that proposition, Your Honor, but it's black letter law. The one case that came to mind was in the state of Steinfeld, cited in our opening motion. Now, why do these black letter rules matter here? Because the governor removed the action filed by Mr. Bailey on May 21, 2020. federal court in the Southern District of Illinois entered a remand order on June 29, 2001. The federal court's certified remand order was filed on the state court docket in Clay County on July 6, 2020. Remanded June 29, certified order filed in the state court on July 6. Between those two dates, June 29, July 6, there was a summary judgment hearing in Clay County and a summary judgment order on July 2. If the issuance of the remand order restored jurisdiction to the state court on June 29, then there was jurisdiction over the matter on July 2. If, rather than the issuance of the remand order, it was the filing of the certified federal court order on the state court docket on July 6 that restored jurisdiction, then there was no jurisdiction on July 2. And the summary judgment order by black letter law is void. Which of the ifs? Heartline provides the answer, Judge. The Illinois Supreme Court determined that jurisdiction was restored after remand upon the filing of the certified order in the state court, not upon issuing or mailing of the remand order. And the issue there was the timeliness of a petition for leave to appeal from an appellate court judgment to the Illinois Supreme Court. Was the petition for leave to appeal filed within 35 days of the appellate court's judgment? The case was decided, and that issue was decided, based upon the calendar, as it must have been, because 35 days is 35 days. There, the appellate court decided its case on March 11, 1990. In a rather unusual twist, you don't see this every day, after the appellate court decided its case, the matter was removed to federal court on April 15th. The remand order from the federal court was issued on July 23. The remand order was filed in the state court on the state court docket the very next day, July 24. The petition for leave to appeal to the Illinois Supreme Court from that March 11 decision was filed on July 25. As a result, here's how the days broke out. 34 days lapsed between March 11, the appellate court decision, and April 15, the removal. And at that point, everything stopped. No jurisdiction, everything, all the claims, all the parties went off to federal court, and everything stopped and was told in terms of timing. 34 days between March 11 and April 15. 2 days lapsed between the federal court's issuance of the remand order on July 23 and the filing of the petition for leave to appeal. 2 days. 1 day lapsed between the filing of the certified remand order on the state court docket on July 24 and the filing of the petition for leave to appeal on July 25. The Heartline Court had to determine which of those 2 days returned jurisdiction. Because if jurisdiction returned upon the remand order being issued on July 23, the July 25 petition for leave to appeal came 36 days after the appellate court's judgment. 36 days. Too late. If, on the other hand, jurisdiction returned to the state court upon the filing of the certified order on the state court docket on July 24, with the petition for leave to appeal being filed the very next day, on July 25, it was filed on the 35th day. So, if jurisdiction returns upon issuance of remand, 2 letters, 36 days. If jurisdiction returned upon the filing on the state court docket of the certified order, just in the nick of time, 35 days. Here's what the court ruled. It concluded that the petition for leave to appeal was filed, quote, 35 days after entry of the appellate court's decision, excluding the time period during which the case was removed, close quote. So if the court accepts the proposition of Mr. Bailey that jurisdiction in Clay County returned upon the remand order of June 29, it goes directly against the holding in Hartland. But that has to be Mr. Bailey's position. It has to be. Because it's undisputed that the certified order was not filed until July the 6th. Why does that make Mr. Bailey have to be July 29? Well, we all know why. Because there was a hearing on July 2. And since we're on the subject of sports, of ambush, this was all laid out to the circuit court on July 2. We've given you the transcript.
Right, I read it. And
Our line was explained to the judge. I went through it probably more laboriously than I should have. And for whatever reason, it was ignored and we plowed forward with summary judgment. But the case, as I said at the beginning, Heartline provides the answer. Remand order June 29, summary judgment hearing July 2, summary judgment hearing July 2. But Heartline tells us jurisdiction didn't return until July the 6th. The day the certified order was filed on the docket of the Clay County Court. Now, what does Mr. Bailey say about that today? A few things. One, ignore Heartline. Ignore it, Your Honor. You have to. Okay. But if you ignore Heartline, where do you look? Mr. Bailey says, well, look at a couple of federal court cases. And he cites to you the Esberger versus Schottback case, a federal district court case, for the proposition that jurisdiction returns upon issuance and mailing from the federal court. I read the case. I'm sure Your Honor did too. It doesn't even address the issue. Far from holding it. It doesn't address the point. The only thing addressed in the Schottback case was, when does jurisdiction leave the federal court? There's no discussion whatsoever about revesting jurisdiction in the state. And then he cites, of course, the Rosenberg case, which is a federal district court opinion from 1979 from the Southern District of New York. Now, Rosenberg did say jurisdiction returned when there was a remand and a mailing. But it was in a footnote, pure dicta. It cited, in support of the proposition, United States versus Rice, the United States Supreme Court opinion, which doesn't even mention the issue, and, of course, more importantly than anything else, a federal district judge in the Southern District of New York in 1979 cannot preemptively trump a holding of the Illinois Supreme Court in Heartline in 1992. We cited the case, Your Honor, and I was almost embarrassed to do it, that stands for the proposition that circuit courts are bound by Illinois Supreme Court opinions. Talk about the black letter rule. There's one for you. Jurisdiction in this case returned to the state court on July the 6th. Black letter. The summary judgment order entered on July 2 is void and should be vacated based on lack of jurisdiction black letter. Now, as we noted in our motion, Your Honor, while the jurisdictional issue is very clear, if for some reason the court sees it differently, then we will address reconsideration on the merits of the summary judgment order, because every court in this state, including this one, including Your Honor, has ruled diametrically opposite to what the Clay County Circuit Judge ruled. But we don't need to get there. When I stood in the courtroom, Clay County Courthouse on July 2, there was no jurisdiction over that case by the circuit court. The orders entered that day were without jurisdiction and should be vacated. The governor respectfully requests, Your Honor, that the motion to vacate be granted. Thank you.
Let me ask you some questions, please.
Of course.
So, I understand your position, I've read the case thoroughly. The Supreme Court is clear. But, I'm just gonna play the devil's advocate here. What if, in our case, or I guess in any case, when the remand order was mailed, what if it got lost in the mail and it's never received by the circuit clerk? So then what are we left with? I know this is the old mailbox rule or something like that.
Well, I can tell you what I would do if I were the plaintiff's counsel in that case. I call up the federal court and say the order didn't show up. And then I get in the car and I drive over to the clerk and get that certified order, and then I drive it over to the circuit clerk in the state court so that it can be filed. Sometimes there's a practical answer to these things. And if a case is remanded, I know it's been remanded, I as a party saw the order, and then the requirements to revest jurisdiction don't happen, then the lawyer should do something about it. It's not that mysterious.
And let me ask you about this. So what about the well-established proposition of law that documents that are included in the records of other courts are subject to judicial notice? Aren't the records of the federal court a public document that this court can take judicial notice of? Because I know the order wasn't received. I have those dates memorized. But courts are all the time asked to take judicial notice of documents, whether they're pleadings, newspaper articles, or something. I mean, that's a public document, and the court could take judicial notice of it.
No question. We're going to ask you in a few minutes to take judicial notice. There's no question that courts do that all the time. Here's why that's not appropriate in this situation. And here's why the Illinois Supreme Court reached the ruling it did. That scenario leaves a possibility that a party in the federal court may seek reconsideration, may go back to the federal judge and say, time out, Your Honor. In all due respect, you blew it.
I don't think you can reconsider it, order of remand, can you?
You can't appeal it. It's not appealable. I could not, if the Central District entered an order in a case of mine to remand today, I could not go to the 7th Circuit. But I could go to the district judge and say, respectfully, you got it wrong, and here's why. The reason for the rule is that once the certified remand order has now left the federal court and has been filed in the state court, everybody knows at that time, everybody knows, the state court has jurisdiction. And there's none of this, I wonder if the federal court's done. Well, it's done, because not only has it been mailed, it's been filed in the state court.
All right, then I found an Illinois Supreme Court case, which I was going to send to you, and I apologize.
And Judge, that's English.
I did.
Say.
So I found an Illinois Supreme Court case, Eastern versus Canty. Did you happen to find that in your research?
I have it on the desk here, Your Honor.
I have extra copies here.
1979?
Yes.
Yes, ma'am.
And the facts are different, they're distinguishable, and If you want a copy here, Mr.
Thank you.
Verticchio, I have, if Mr. DeVore has a copy. I know that yes, please, the Heartland case was very specific with those dates. And I know that this case that I found, I think is older than Heartland, right?
Yes,
It was
yes,
Heartland.
that was the first thing that leaped off to me. Your Honor.
Yes, I know
Heartland
that
was 1992.
is older. But this case says, if you look on page 4 at the top, it says the court will not have to wait for a technical order of remand before proceeding to exercise its jurisdiction to dispose of the case. And I know it's not fair to you because I haven't given, and it goes on and it outlines, this was something that was filed in the wrong federal court. Venue was improper. So he dismissed the petition for removal because it was not proper.
And I'm sorry, Your Honor, I'm not seeing where you're reading from the opinion.
If you look on the, I'm sorry, the very top of page 4, first column on the left.
Where,
The first word is circumstances.
page number 4?
No, I'm sorry, Westlaw number 4 down here at the bottom, not the citation. Is your case, are you looking, your case might be double-sided.
It is.
So that might be confusing you. So, it says on mine here, is that right? Am I missing?
I circled page 4, I went to the left-hand column and it begins with, we think this observation.
All right, then it must have printed differently on yours. So go to your page 3 then, because it's right above that.
What word does the paragraph start with, ma'am?
Well, on mine, I must have printed mine at a different, because I just printed those for you today. So let's go to the citation reference 573, okay?
573.
Begin with, had the order of November 4.
Yes.
Yes.
Had the order of November 4 remanded the case, the circuit court would thereby have reacquired jurisdiction, and it cites Brown versus State Farm.
Right, the Texas appellate court opinion.
Correct, yes. While the order here did not remand the case, that was unnecessary as it was based on a determination that the filing of the defective petition had not affected removal. And the order served to terminate the proceedings in the district court. So I told you, the facts are different. The petition for removal was not perfected, so they dismissed it. But they go on, if you go down there below, the effect of the order of dismissal, and you read there, at the end of that paragraph, it says, the court will not have to wait for a technical order of remand before proceeding to exercise its jurisdiction to dispose of the case.
Okay.
We note the clerk of the district court did not mail to the clerk of the circuit court a copy of the November 4 order. Even if that order had been cast in terms of a remand, this omission for the reasons given in Brown versus State Farm would not have been significant. So again, I'm giving it to you, the facts are different and all that. But this is an Illinois Supreme Court, and the way I read it, it's saying that the actual filing of the order is just a little technical omission that should not make a difference. And if you-
Accepting that it was not a remand, and that makes all the difference in the world, because that triggers federal statute 20 U.S.C.
1447.
1447C. And in this case, Eastern versus Campy in 1979, whatever the court had to say about that was certainly dicta, because it wasn't even a remand case.
Right.
And then the court makes this statement, and they cite a 1969 appellate court opinion from Texas. Okay, I mean, it's an observation known in our world as dicta. And that observation, for whatever it's worth, I don't think there's any doubt in the world that it's completely contrary to what the court held in Heartline after full consideration of the issue in 1992, 13 years later. So I guess if I step back to where I finished, this court is is bound by the decision of the Illinois Supreme Court, the most recent decision that fully explored the issue and came down with a clear, workable rule. Jurisdiction revests in the state court upon the filing on the state court docket of a certified order of remand.
Okay,
Thank you.
thank you.
I will use the podium, Your Honor. Couple of things to start, Your Honor, before I get to the essence, is we're talking about ambushes. On July 2nd, that was an ambush of not only my client, but of the Honorable Judge McKinney. Now, most of the things that you're going to hear Mr. Pritzker and I argue as these cases proceed is that we have differences of opinion of the law, of interpretation.
Okay,
I can tell you with this particular issue here, with all due respect, my colleague is wrong. And I say that unequivocally. Heartline does not stand for the proposition that the certified copy of the order has to be filed in the court before jurisdiction is revested. It says no such thing. And I will get to that. I don't think there's an argument that the court's aware, they attach it as an exhibit, that on June 30th, the court of the Southern District of Illinois mailed that order, the certified copy, to the Clay County Court. It's in the record, it's not in dispute. The court is aware, as it relates to jurisdiction, that this court, as well as Clay County Court, they have original jurisdiction over a lot of matters. Mr. Bailey's case was no different. And when the order to remove was filed under 1446, the state court's ability to proceed is suspended and held in abeyance until the federal court does something.
right.
Right?
Yep.
And it says in 1446, and I'm reading from it, the state court loses jurisdiction to proceed until the case is remanded. Mr. Pritzker said the same thing. Until the case is remanded. That's what the federal law says. They said until we remanded it, and we're going to get to what it means to remand. Once we've done that, this court, the federal court, no longer has jurisdiction. 1447C, which has been talked about, I'm going to read it. If at any time before final judgment it appears that the case was removed improvidently and without jurisdiction, the district court shall remand the case and may order the payment of just costs, etc. A certified copy of the order of remand shall be mailed by its clerk to the clerk of the state. It doesn't say anything in the rule about issuance. You heard my colleague talk about the issuance of the order or the filing of the order. The word that he left out, I would humbly suggest on purpose, is the mailing of the order. That's what the rule says. And the state court may thereupon proceed with such case. Now, Your Honor brought it up, this issue of mailing. If the court looks at the rules and the law of the federal court, what is that issuance of mailing? Why is it important? Because Mr. Pritzker was right. There is an opportunity for a federal judge to reconsider whether or not that was a proper ruling. Do you know when that is over? Once it's been mailed? Once that order has been mailed out, the local district court is unable to then change its mind. Not to appeal. We're all in agreement here. You can't appeal that. But that federal judge can change his mind. He can change his mind. Once he mails it, he no longer can do that. 1447C, Your Honor, came into existence in 1976. Before that, we had 28 U.S.C. 71. 28 U.S.C. 71 was written differently, and it said, after the order of remand, the remand shall be immediately carried into execution. That's what the old rule said. There's cases all over the place about what does it mean immediate. Is it self-executing, which means once that judge signs that order, is he foreclosed from ever being able to reconsider? The case law developed that issue. And you know, prior to when 1447 was created in 76, you know when they were no longer able to do that? When it was filed in the state court case. That was the case law that developed that Mr. Pritzker now presents to this court. That's what it was. That's where the whole filing in the state court became relevant, because under the old statute it said immediately that it would revest, or it would go back to the state court, and immediate, there were cases that were arguing, well, as soon as he signed it, it's over. No, it had to be filed. That's no longer the rule in the federal court. The federal court rule is clear, it's crystal clear, that upon mailing, it says right in the rule, the state court may thereupon proceed with such case. It means federal court's done. Now my colleague would suggest to this court it provides no authority, none, and I looked, that there's this jurisdictional limbo, that no court in the United States of America has jurisdiction over a case. Your Honor brought up a good point. I was going to argue it actually. It gets thrown in the mail, it gets lost. Mr. Pritzker gave all kinds of practical solutions, but jurisdiction is jurisdiction. There is no authority that says, regardless if it takes, I had somebody mail me something from a county away last week, Your Honor, it took 12 days to get to me. The proposition that once it's mailed, until it's received and filed, that there's this jurisdictional limbo, there's no authority for that whatsoever. The court looked at the Eastern v. Canty, read the proper, it was not a remand case, it doesn't matter. And the court has the rule in there that it talks about, we just talked about. And it said, had the order of the November 4th remanded the case, the circuit court would have thereby reacquired jurisdiction, citing Brown, upon mailing. Because again, the mailing is the trigger to where the state court no longer has to say, well, wait a second, if I start making substantive rulings, and then that federal judge says, wait a second, somebody's asking me to reconsider, and I change my mind, the state court could be engaging in a lot of void, I agree with Mr. Pritzker, decision making. That's why the mailing strikes it off, Judge. The law is clear, crystal clear. Now let's talk about Hartman. My colleague would suggest to this court that Hartland is unequivocal that filing in the state court is what revests the jurisdiction to the state court. Hartland doesn't remotely say that. It didn't even come close. It is true there were 34 days from the time that the order was entered until they sent it to the appellate or to the federal court. And I'm going to read. I'm at the paragraph under where it's the only one that really matters in this case, where it talks about Supreme Court Rule 315B provides that if an affidavit of intent, I believe it's around 725, 726. And it talks about, on April 15th, Illinois Power filed a notice in the circuit court removing the case to the federal court. Then it says, reading closely, we take judicial notice, see May department stores, that a certified copy of that order was filed in the circuit court on July 24th. They took judicial notice of the fact that it had been filed in the court. Okay, I'm fine with that. You know what it doesn't talk about? When it got mailed. Obviously, if it was filed in the court on the 24th, that is a very conservative calculation under this Rule 315B. Because obviously if it's filed in, it was mailed and delivered prior to that. So if your worst case scenario is filing, you got no violation from a jurisdictional perspective. Again, this is not a jurisdictional question either. It's a calculation of the 35 days. They're not even, this case doesn't even address whether this court had jurisdiction in that regard of calculating 1447. But it just says a certified copy, they took judicial notice. And then it goes on to cite the rule. A certified copy of the order of remand shall be mailed by the clerk of the court, clerk of the state court they thereupon proceed with the case. Hartland even cites the federal rule. It cites the federal rule. And I go up to the next page, I'm also on Heartland. When a petition for removal has been filed in the federal district court and other requirements of 1446 have been met, the state court loses jurisdiction to proceed further until the case is remanded. It doesn't say until the case is remanded and the order of remand has been filed in the court. It doesn't say that. And again, coming back to the time frame, Judge, which is really, when you read their reply, they go, well, this is 33 days, 34 days, and if you do this math calculation, you've seen their reply, none of that in here. If you accept the date of filing as the date out into the future the farthest, they still meet the time frame. They say, well, if the date of issuance, or Mr. Reticchio, if we use the date of issuance, then it would have been more than 36 days. So by inference, we have to conclude that that's what this court meant. That's what he's asking you to do. But you know what date's not in here? The date of mailing. I don't care about the date of issuance. The federal court doesn't care about the date of issuance. What if it's issued on day one and they don't mail it for 3 or 4 or 5 days or a week? Until it's mailed, that whole period of time, that federal court has the ability to change its mind. And until that thing gets mailed, a state court, according to the clear interpretation of the rule, has no jurisdiction because that federal court might change its mind. Once it's not changed its mind and it's sent out its door, it's over in the federal court, and the state court can proceed with confidence that its jurisdiction is not going to be questioned, Your Honor. That's what Heartland stood for, and just because it was filed in the court on the 24th has nothing to do with it. Nothing to do with it whatsoever. Now, Mr. Reticchio suggests to the court what we all know to be the case, that if this court doesn't agree with them on this jurisdictional nuance that they're trying to raise, they're going to come back and ask this court to set aside Judge McKinney's motion because they disagree. And because every other court in the state, I've heard it over and over and over ad nauseum, disagreed with Judge McKinney. Okay, that's fine. We can get to that. But to do this, if they want to make that argument to you and they want you to agree, I'm okay with that. I disagree, but I understand your discretion. But are we really going to call these proceedings into question on a jurisdictional issue that's this thin? That they're trying to suggest that Heartland completely controls jurisdiction of the state courts? The state courts always got jurisdiction, ma'am, unless the federal court has taken it away for some amount of time, and the federal court rule is unequivocal. It is clear that upon remand, and remand means mailing it, and then the state court can proceed. That's the law that controls when the federal court loses jurisdiction. There is no authority whatsoever. Once 1447 was enacted and USC 71 was no longer in effect, there's no authority to suggest anywhere that a state court has to accept and take a certified copy of that order. The court can look at all at once prior to 1976. You'll see all kinds of cases that will support that. UC was a big one that really laid out that you got to file it in the state court first. It's not the law anymore, Your Honor. It's not the law, and I'd ask the court to find the jurisdiction was there. And we can proceed and they can file all the motions to set aside Judge McKinney's order they want on the merits, and we can address those. But I'm asking the court not to do it on such a thin argument based upon jurisdiction that's not even supported by law. Thank you.
Thank you.
Thank you, Ron. Mr. DeBoer told you, I wrote it down, quote, Heartline doesn't come close to holding back, close quote. It's the only possible reading of Heartline. Mr. DeBoer told you, but when was it mailed? When was it mailed? And then he pointed out to the court that the Heartline Supreme Court took judicial notice of the filing on July 24. The filing in the state court on July 24, and Mr. DeBoer told you that the mailing was his words, obviously prior to that. And while it's true, Heartline doesn't discuss mailing, we know when it was mailed. Because the decision was issued on July 23. The certified order was filed in the state court on July 24. Well, apparently in 1992, the mail was extremely efficient. But it wasn't so efficient that it was mailed on the same day it was received. So we know it was mailed on July the 23. What else do we know? We know that the court held unequivocally that if jurisdiction restored to the circuit court on July 23, which we've now established as both the remand order date and the mailing date, the petition for leave to appeal was filed 36 days after the appellate court opinion. Too late. But if jurisdiction returned on July 24, the date of filing in the state court docket, then the petition for leave to appeal was filed on the 35th day, just in time. And that's what Heartline held. There can be no mistake about it. It's the only possible reading. Now, Mr. Bailey wants it not to be so. But it's the only possible reading. And as a result, on July 2, the Clay County Circuit Court did not have jurisdiction. Mr. DeBoer tells you, you can look at all the cases you want before 1976 and you'll find this or that. To which I say, you don't have to do that. You only have to look at one case. It's from the Illinois Supreme Court. Cited in 1992, and it's unequivocal. The other thing that Mr. DeBoer told you, his words, quote, jurisdiction is jurisdiction, close quote. Couldn't agree more. And on July 2, 2020, the Circuit Court of Clay County did not have jurisdiction over this case. The summary judgment order is void for lack of jurisdiction and should be vacated. Thank you, Your Honor.
No,
Judge, might I add one thing on one roof issue?
I'm fine with that. Do you have any objection, Mr.?
Well, I'll let you know after I know what he has to say.
Thank you.
Go ahead.
Judge, we know what Heartland says. We know what it doesn't say, kind of. You know what it doesn't talk about? Is if the order was even mailed. We don't know. It's not in the record. For all this court knows, or my colleague knows, an attorney could have taken a certified copy and walked it into the court and filed it. The record is nothing on that. It'd be interesting to know. I don't think we need to. But to ask this court to infer, well, if the order was entered on this date, they had to have mailed it the day before because the mail was really efficient 28 years ago. Seriously? For all we know, it wasn't even mailed. For all we know, if it wasn't mailed and it was filed, maybe there was no jury. We don't know any of that. We're speculating. I would ask the court not to speculate on when it might have been mailed or when it might have. We know when it was filed. We don't even know if it was mailed, Judge. And again, for that reason, I'd ask the court to not follow our line.
Your Honor,
Yep.
Mr. DeBoer launched into this hypothetical about mailing. My only point is, it doesn't matter. The court was clear. Jurisdiction vested when it was filed in the state court docket, period. Thank you.
Thank you. All right, let's take a 10, 15-minute break, and then I'll come back.
Thank you.
And we'll proceed further,
Thank you.
okay? Everyone else ready?
Yes, ma'am.
All right. We'll go back on the record then in 2020, MR 589 in re COVID-19 litigation. The parties just finished arguments on the motion to vacate the July 2nd order for lack of jurisdiction. The court is going to take that under advisement. I will issue a written decision as soon as I can. Moving on to the housekeeping matters brought up by Mr. Pritzker regarding the briefing order. I understand your position. I understand your position. I like to enforce my orders, but I don't see the harm in letting Mr. DeVore argue today. If the AG, after hearing his arguments, wants to order the transcript and file a written response, I will let you do so. I will not allow Mr. DeVore to file a reply. If you are satisfied, you have fully briefed everything, I believe. If you're satisfied with your pleadings, then I will just rule based on what I have. But we're here. I feel arguments help the court, so I want to hear what both parties want to say. Like I said, I don't think the motion to add count 5 is rocket science, but I will hear what the parties have to say. I've already read everything that the governor has filed, but I'm willing to hear arguments on that. So let's do that first, because that's what I have next in my set of pleadings, is a motion for leave to file an amended pleading to add count 5. So, do you have anything to add right now, Mr. DeVore?
Just my colleague and I were talking, Judge, if it was okay, and I believe he was going to address the court, is that there's a huge overlap on the additional adding count 5 and the motion and the county cases,
Right.
with the caveat of timeliness. And so I believe we were going to be okay with arguing at the same time, I believe. And I have no objection if my colleague wants to do that.
Yes, Your Honor, that's absolutely right. These cases really do present the same legal issues. Our primary objection in the motion to add count 5 is that it would be futile because the proposed new count fails to state a claim. And it fails to state a claim for the same reasons as we argued in what we're calling the county disaster cases.
Okay.
So my suggestion, Your Honor, if Mr. DeVore is in agreement, is that I would proceed with argument in the county disaster cases. That will more or less be our argument with respect to the motion for leave to add count 5 as well. So.
Okay.
No objection from us, Your Honor.
All right.
Thank you, Your Honor. Your Honor, at the outset, may I ask for permission to remove my mask when I'm speaking?
Yes.
For the court reporter's benefit, I've been told I speak very loud, or very softly and very quickly, so I'm hoping this may help.
No objection, Your Honor.
Any objection by anyone in the courtroom? I want everyone to be comfortable. Okay. And I think it would help you. Yes. All right, yes.
Thank you, Your Honor. I appreciate that. Your Honor, as you know, there are 6 complaints, each of which was filed in a different Illinois county and then consolidated here before you. But each one of them presents the same legal issues, the same theories of recovery, and they are materially identical in all aspects other than the county in which they were filed.
Okay.
And the names of the plaintiffs, of course.
Right.
Now, as Your Honor knows, since March 9th and every 30 days thereafter, the governor has declared the COVID-19 pandemic to be a public health emergency. A public health emergency is a term of art under the Emergency Management Act. Public health emergency is defined in Section 4 of that statute to be a disaster. And under Section 7 of the statute, when the governor declares a disaster to exist in the state, a disaster like a public health emergency, he then has 30 days of powers, emergency powers, under the Emergency Management Act. Now, the allegations here are very straightforward, Your Honor. Plaintiffs have alleged that COVID-19 is not a public health emergency that exists in their particular counties within the meaning of the Emergency Management Act. And the conclusion they draw from that factual allegation is that therefore the governor cannot exercise Emergency Management Act powers in their counties. To put it another way, Your Honor, the theory is the governor can only exercise emergency powers under the Emergency Management Act in a particular county if there is a statutory disaster in that county.
Okay.
Now, Your Honor, there are three independent reasons why these complaints must be dismissed and be dismissed with prejudice. Any one of these three reasons is sufficient for you to dismiss. And I'll start with the first, the most obvious, and where we always start, with questions of statutory interpretation, which is what this is. The question is, does the plain language of the statute support the theory that plaintiffs have put forward? Does the plain language of Section 4 and Section 7 of the Emergency Act support their theory that the governor can only exercise emergency powers in a county if there is a disaster that exists in that county? And the answer from the plain language of the statute is no. No. In fact, the statute in its plain language establishes the opposite. The statute establishes that the General Assembly can seek the disasters and the governor's exercise of emergency powers on a statewide basis, not a county-by-county basis, not on a municipality-by-municipality basis, not any sort of political subdivision within the state. The plain language of the statute establishes that the governor is able to exercise emergency powers in this state if a disaster exists in this state. That is what the General Assembly said. And I think in some ways, Your Honor, this case rises and falls on a principle of Illinois law that I think is beyond refute. And it appears in many, many cases, many Supreme Court cases. The one that we happen to cite is the Ulch case. That's U-L-T-S-C-H. And the principle is this. There is no rule of statutory construction that authorizes a court to declare that the legislature did not mean what the plain language of the statute says. There is no such rule of statutory interpretation. That is exactly what plaintiffs ask you to do, Your Honor, in these consolidated cases. And for that reason, and that reason alone, the complaints must be dismissed. They must be dismissed with prejudice because of the legal error. But as I said, there's a second reason too, a second reason why the complaints must be dismissed. Even if the plaintiffs are correct on that question of law, so in other words, even if they are correct that the governor can only exercise emergency powers under the statute if a disaster exists in their counties, plaintiffs fail to allege specific facts as required under Illinois law to establish their conclusion that no public health emergency exists within their counties. They don't allege any specific facts that shows that COVID-19 does not satisfy the statutory definition of a public health emergency. Now, plaintiffs have conceded that COVID-19 is an illness that has occurred in their counties. They don't dispute that. And plaintiffs also concede that the occurrence of COVID-19 in their counties is believed to be caused by the appearance there of a novel infectious agent. They don't dispute either of those 2 points, Your Honor. And if you look at the definition of public health emergency set forth in Section 4 of the Act, those two concessions roughly correspond to Subpart A of the definition. But the definition has 2 parts, Subpart A and Subpart B, and both of those subparts must be satisfied for there to be a public health emergency. And it's Subpart B where plaintiffs dispute the existence of the fact necessary to satisfy that definition.
Okay.
Plaintiffs, the final requirement, Your Honor, set forth in Section B, Romanet 3 is, does COVID-19 pose a high probability of widespread exposure to a virus that poses a significant risk of future harm to a large number of people in the affected population? So the key words there, Your Honor, in B3 of the definition of public health emergency, the key words are probability, risk, future harm. Probability, risk, and future harm. This is all about what is going to happen in the future. Is there a risk? Is there a probability of harm satisfying the definition in the future? That's the critical inquiry under Section B3 of public health emergency as defined in Section 4 of the statute. So what specific facts do plaintiffs plead to support their conclusion that this requirement isn't satisfied? Well, they just allege 3 facts, Your Honor, 3 facts in each county. And those facts are the total number of people who have been tested in each county for COVID-19, the total number of people who have been infected with COVID-19 in each county, and the total number of people who tragically have passed because of COVID-19 in those counties. Those are the only 3 facts that plaintiffs have alleged in support of their argument that COVID-19 does not satisfy the statutory definition. And those facts are plainly inadequate, Your Honor, because they speak to the present harm, not the future harm, not the risk or probability that something terrible will happen in the future, which is the requirement under the public health definition, public health emergency definition. They only plead facts about what's going on right now. And for that reason, again, that reason alone, the complaints must be dismissed. In essence, Your Honor, this is an argument that a large number of people must fall ill and die before the governor can do anything, take any action in their counties to prevent the spread of COVID-19. Until a large number of people die, they don't tell us how many, but until that happens, the governor has to sit on his hands and do nothing. That is not what the General Assembly said when it defined what a public health emergency is. That's not what the General Assembly said when it defined what a disaster is. That is a stunningly immoral and illogical argument, Your Honor, but it also contradicts the plain language of the Emergency Management Act. That's the second independent reason why the complaints must be dismissed. And the third reason, Your Honor, is standing. Because you will recall at the outset, I mentioned that the governor has, since March 9th, and every 30 days or so after, declared that COVID-19 is a public health emergency under the statute. Well, he's done another thing as well. He's also declared COVID-19 consistently to be both a public health emergency and an epidemic under the statute. And both a public health emergency and an epidemic are types of disasters within the definition of Section 4. Now, plaintiffs in these consolidated cases have not challenged the governor's declaration of COVID-19 being an epidemic. They have not challenged the question of whether or not COVID-19 is an epidemic that exists in the county. They have left that unchallenged entirely, Your Honor. And so no matter what happens in this case, no matter what happens, even if Your Honor agrees with every point they make, every argument they make, Your Honor says you guys are completely right in every point that you are bringing before me. The declaration that they're asking you to enter, that there is no public health emergency in their counties, will not redress the injury they claim. The injury they claim is being subjected to the governor's exercise of emergency powers under the statute. But even if Your Honor says there is no public health emergency in their counties, that will still leave an independent basis for the governor's exercise of emergency powers in those counties, the existence of an epidemic. Because I haven't challenged that, the declaration I seek from you will not redress their injuries. And we know from many cases, including the Cluck case, KLUK, cited in our brief, that to have standing, to get a declaration, to have standing to bring a declaratory judgment action like these, you must be able to show that the declaration you seek will redress your claimed injury. Plaintiffs cannot do that here. And any amendment would be futile, Your Honor, because the definition of public health emergency, as I just alluded to, is quite complex. There's a lot of, a lot of different subparts which plaintiffs can bring arguments about. But the definition of an epidemic is much, much simpler. Epidemic is not independently defined in the Emergency Management Act, which means that we give it its plain and ordinary meaning. Now, every single public health authority in this country, and I believe in the world, has declared COVID-19 to be a pandemic. That's how we're used to referring to it in everyday conversation. It's a pandemic. What is a pandemic? A pandemic is an epidemic that no longer exists just in one country or region of the world, but rather exists in multiple countries or regions of the world. So a pandemic, by definition, is an epidemic. It would be futile for plaintiffs to attempt to amend their complaints to also challenge the existence of an epidemic in their counties, because they can see that COVID-19 exists there, and COVID-19 is an epidemic, certainly under any common meaning of that word. So for that reason, again, the third reason, plaintiff's complaints must be dismissed. It must be dismissed with prejudice. Your Honor, I think I'm going to reserve the rest of my time to rebut whatever Mr. DeVore may say. Of course, I don't know exactly what he's going to say given the circumstances we just discussed. But before I do that, I wanted to put a few facts in the record, facts that you can take judicial notice of, because they come from the Illinois Department of Health's website, the COVID statistics website that we cited in our papers.
Okay.
So out of the 6 counties that are issued here, the 6 counties in the consolidated cases, and then Clay County through Representative Bailey's motion to add count 5. Out of those 7 counties, 3 were identified last Friday by the Illinois Department of Public Health as being at a warning level for rapid increase of COVID-19. They were identified as being at a warning level because of the level of COVID-19 activity happening in those counties. That's Clinton County, Richland County, and Clay County, all identified as at a warning level by IDPH. And Your Honor will recall from our papers that previously Sangamon County had been on that list a couple of times, and so had Bond County. So that brings us to 5 of the 7 at various points over the past 6 weeks have been identified as at a warning level by IDPH for the rapid increase in COVID-19. And the numbers are worth reading into the record on because they're quite something. In Richland County, 324 new cases per 100,000 people, and an 8.9% test positivity rate. 8.9% of every test comes back positive. The IDPH has identified 8% as a warning level. They're above that. That's what got them on the warning list. In Clinton County, the numbers are worse. 340 new cases per 100,000, and a 12.3% test positivity rate. 12.3% against a threshold of 8 for being a warning. And in Clay County, we have 279 new cases per 100,000 and 13.4% test positivity rate. 13.4%, Your Honor. And Illinois as a whole is not doing well either. We now have almost 325,000 total cases confirmed in our state, over 9,000 deaths. On Monday, Your Honor, on Tuesday, we announced 2,851 new cases in one day. 2,851 in one day. That's the 7th day in a row with more than 2,600 new cases. And just to put that in perspective, Your Honor, we all know that we peaked the first time around in May. There was a rapid increase in COVID in our state, and we peaked during the month of May. During that peak in May, we were averaging about 2,500 new cases per day throughout the month of May. And then we plummeted, really, going into the month of June. We plummeted all the way down towards the middle of June and the end of June. We were at approximately 600 new cases per day, 600 statewide. So we peaked at 2,500, we went down quickly to 600. But ever since the end of June, Your Honor, things have been steadily going in the wrong direction. They've been steadily going upward. The number of new cases per day has been rising since June, and it's just now got to the point where we're actually above the levels that we were at in May, statewide. We're having more new cases of COVID-19 right now, today, in Illinois than we ever have at any point during this pandemic. So the danger is real, Your Honor. The danger is real. Now, as I said, I will rest for the moment, unless Your Honor has any questions, and wait for Mr. DeBoer's response.
No, I think your comments address all the questions that I have written down right here. Thank you. Is that pink for October?
No, ma'am.
Or is it not pink?
I was desperate and my 17-year-old daughter was the only one she had. Does Your Honor remember when we were standing in your courtroom almost 2 months ago, and the first word that I said to the court was the same thing that I'm going to say to the court today? I just listened to my colleague, who I thought did an eloquent job, and everything that I heard, I hear one word, and I've heard it for months: fear. I said it before, and I'll say it again, Your Honor. Fear is what's being used to drive decisions and acquiescence. I'm here to talk about the law, not fear. The governor, for months, has argued, my esteemed colleague, Mr. Pritzker, all along, that the governor has emergency powers. And those emergency powers are the result of the issuance of a proclamation of disaster. This court knows there's a big argument in what that means, but let's accept that conversation as true. Governor further suggests that the only basis by which a citizen of this state can contest his emergency power is by attacking the proclamation of disaster. It's in the record across numerous cases, Clay County in particular, numerous times. If you want to test the emergency power, you got to test the proclamation of disaster. Okay, here we are. Now, what do you hear? If you read their motion to dismiss, and if you read their memorandum, which lost track of how many pages it was, numerous, but one of the propositions that they bring to this court, which is one of the most precarious of the three, is you should dismiss this cause because all you need to do, court, ma'am, is to look at our facts. They're indisputable. They're irrefutable to support the proposition that there's a public health emergency. Dismiss the case. The court should not continue this case through the discovery process. Take a look at, when I read this thing, Judge, I lost track of CDC fact sheets. I've got a Wall Street Journal report. This court's discretion should yield to the Wall Street Journal. KMOV, I think that's a news agency in St. Louis. So not only has the governor been exercising extraordinary executive power contrary to any involvement by the legislative branch of government, he now stands in this court today asking Your Honor to disregard her discretion and just believe what he says and accept it as true. If that's what the separation of powers means, I'm going to become the most successful lawyer in the country by going into courtrooms and saying, here's my client's facts, Your Honor, dismiss their case because my facts are true. My client says so. That's one of the things they're asking. I read that, and that's why I didn't file a response, because I wanted to stand here and make that clear that that's one of the things they're asking Your Honor to do. We don't need a judicial branch of government anymore. We don't need a legislative branch. We've got the executive branch. He's doing everything that he needs to keep people safe. Everything's a public health emergency. Now we got epidemic. They threw that in. And here's our facts. Here's our CDC. The Illinois Department of Public Health documents that they are presenting to take judicial notice. I have no problem with that. But they're asking you to defer your judgment to those. No. That's not how the separation of powers works. This court has its own discretion. It gets to test the evidence. It gets to look at the facts. And if there's a reason that the court wants to dismiss this case, it should not be because it's going to accept what they present to you as fact. And it's being, I've read it, I've written it in there, it's written in there numerous times, it's undisputable. Yes, it is undisputable. That's why we're here. Do we have a public health emergency? That's the question for Your Honor to answer. And we'll get to the details of county by county or statewide. That's your discretion. That's this court's discretion. It's not the governor's discretion to give it to you and say accept it as true. Now in the complaints and the request by Mr. Bailey to add, they attack the definition of a public health emergency. It's in the statute. My colleague is correct. It's not been in there all along. The most recent, as this was pled, I think it would have made maybe the late June executive order, they threw in the word epidemic. Now, epidemic is listed as in Section 4 of the IMAA as a separate potential disaster. I looked it up of what it means. A widespread occurrence of an infectious disease in a community. Sounds an awful lot like a public health emergency, but that's okay. If Your Honor says and agrees with my colleague that, well, yeah, you've attacked public health emergency, but you've not attacked epidemic, that's not a basis for dismissal with prejudice. We'll amend the complaint, add epidemic in. Doesn't change the substance of the case, because if you don't have a public health emergency, and you would find that, you don't have an epidemic either. They're the same definition almost. It's redundant. But my colleague is correct. We didn't plead epidemic. It's not in any, if Your Honor looks, it doesn't really matter, but if you look at every one of the proclamations prior to again, when this was filed, the most recent, I think it was June 26th, they threw the word epidemic in. But the court heard my colleague really taking issue with public health emergency. Because that's where the crux of this comes from, Judge. Now, I'm going to get to it. I want to throw this in now. There were some statistics thrown out of last week, etc. I'm fine with that. I mean, this issue is very complex, and so it suggests, like Mr. Berticchio, that we need to nail it down and have everything in the document. I don't support that. My colleague didn't support either. He was giving you facts and science from 2 days ago. I'm okay with that, but I'm going to give the court a couple of those too. The complaint for declaratory judgment asks for more than one thing. It asks this court to find that no public health emergency exists, and I got the Sangamon County one in front of me. We're here, so I grabbed it.
Yeah.
Existed on June 26th, as defined by Section 4 of the Emergency Management Agency Act. That's one request for declaration that we ask Your Honor to find. We also ask this court to declare that the governor has no emergency power as defined in Section 7 of the Illinois Emergency Management Agency Act in Sangamon County, given no valid proclamation of disaster lies. Obviously, that particular request to you is predicated on you would have to first find that no disaster existed. Could Your Honor find that a disaster does not exist in Sangamon County, but yet conclude, based upon an interpretation of the statute, that the governor could still wield emergency power in it? It's a precarious proposition, but I guess it's possible. We have, up until COVID came, most of the disaster proclamations that have been entered by governors in our state have to do with floods. If we have a flood over on the west border of our state in a couple of counties, does that mean the governor can issue emergency powers in Clay County? Certainly they don't stand for that proposition. But again, that doesn't defeat the cause of action. The crux issue is first and foremost is there a public health emergency in Sangamon County? And can we argue? That's at least a legitimate request. Can we argue that, isolated county by county, is there a public health emergency? The governor's proclamations, Your Honor, speak for themselves. Every one of them. Even after we raised these arguments, the governor didn't change it. I thought he might. It says that he declares a disaster exists, not in the state of Illinois, in all 102 counties. He specifically identifies the counties, all 102 of them, in his disaster proclamation. Each and every one of them. As he has unilaterally managed, or ruled, or whatever word you want to put on it, he makes decisions that aren't statewide decisions. He makes decisions on countywide basis. The court knows he pulled Champaign County out of the Region 6 calculation for positivity. He issues region-wide mitigation. Region 1 now is in some new mitigation. Region 4 was. So he's making decisions that aren't statewide, but he's suggesting to this court in these pleadings that his disaster proclamation is all or nothing. You have to attack the whole state. Not only is he not managing this effort that way, ma'am, his proclamation, which is the most important thing, does not say that. It says all 102 counties he deems a disaster. That clearly gives my clients the right, again, let's just use Sangamon County, they're all the same, Mr. Bailey's the same, to say, wait a second, this proclamation says my county, not the whole state, my county is a disaster. I'm one of the 102. I don't think we have one in Sangamon County. I don't think we have one in Clay County. We want you, ma'am, to make that determination. Again, what that means after you would make that determination, still a conversation of debate, whether or not that means the governor can wield emergency power in that county. It's not conclusive either way. Have we pled enough facts to survive a motion to dismiss? Fact being state, I'm going to put them on notice of what we're arguing. I have a copy of the pleading, and I'm going to read from the statute. Section 4. Public health emergency is an occurrence or an imminent threat of an illness or health condition that, and there's two parts, as you were explaining, two parts, The appearance of a novel or previously controlled or eradicated infectious agent or biological toxin. COVID bad? We're not arguing that here today. Don't need to. It's a virus. We all know that. It's no secret. Paragraph B gets a little bit more precarious. Because you gotta have both. It's conjunctive. A high probability. High probability. What's that mean? That's for you to decide, man. A large number of deaths in the affected population? What's a large number of deaths? In Sangamon County, you got 197, 98,000 people in this county. What's a large number? That's for you to decide. Paragraph B, subsection little part 3, that's where the wording gets a little bit more complicated. Now, my colleague suggested there were words in there that you should look at. I don't think he gave you the right words. Widespread exposure. It requires a widespread exposure. What's widespread exposure? That's for you to decide. That's not for the documents that they ask you to take judicial notice of and to say that's conclusive. Widespread exposure because the CDC says so, or the Department of Health, the governor runs, says so, or some article from the Wall Street Journal says so. That's what you say. Is there widespread exposure? It's for you to decide. That poses a significant risk of substantial future harm. What's that mean? For you to decide, man. Of a large number of people. So a widespread exposure, a significant risk of substantial future harm to a large number of people in the affected population. Is COVID-19 on June 26th? Is COVID-19 on October 14th? Because you know a lot of time's passed since June 26th, right? We know that. Does it fit that category? That's the question for you to decide, and my clients are asking you to decide after you get the evidence. Depositions, interrogatories, all of that good stuff. My colleague talks about positive cases. I know Your Honor, probably like every citizen in this state, pays attention. Are all the negative cases getting recorded to the Department of Health? That's a good question, right? How are we ever going to find out the answer to that? Discovery? They don't want my clients to do that. They want you to throw the case out so we don't find out whether or not that's true. Because if all of the negative cases aren't getting reported, positivity is inflated. I know that too. Is it happening? I don't know. I'm not going to stand here and say it is. That would be improper. I don't know. They're asking to not give my clients the chance to look. Now, when we pled this, we said that that definition is not met, and we gave some information to this court as of July 22nd. For, again, I'm using Sangamon County as an example here. 1.59% of those tested were positive for COVID, July 22nd. Is that widespread? Again, you're eventually going to have to answer that question. 0.363% of the county's population. That's the affected population in Sangamon County. This is 198,000 people. 0.363% of them that tested positive as of that date. And again, any number's too big, but we're doing statutory interpretation. As of that date, 0.017% of this county's population had passed. Does that meet a large number of deaths in the affected population? That's for you to decide, man, at some point. And my colleague gave, that was in July 22nd, Your Honor. My colleague gave you some numbers from last week. Again, the goalpost is moved to positivity. At one point in time, it was flattening the curve, so we don't overwhelm medical facilities. Noble idea, didn't happen. Now, we're talking about positivity. October 13th, most recent data, court can take judicial notice, as you did all the things my colleague asked you to. Sangamon County, again, we still got 197,000 give or take people according to the census. As of October 13th, 117,471 people in Sangamon County have tested. That's almost 60% of the county's population. Significant. The percentage of the population of Sangamon County that's tested positive? 1.55%. Is that, going back to the definition, is that a widespread exposure of COVID? 1.55%? No. I would hope the court would say, I need to hear some more about that. I'd say today, yes or no. They're asking you to say yes. I'm not asking you to say no. I'm asking you to say, we need to take a look at that. We've had, unfortunately, in Sangamon County, 50 people pass away. They pass away from COVID? We don't know. If we believe these numbers to be accurate, we know they hopefully had COVID when they passed. Did COVID cause them to pass? They've cited CDC reports, asking you to consider them. I wonder if they cited the CDC report, to your honor, that says, according to their statistics, 6% of COVID deaths are COVID deaths and not subject to other comorbidities. Don't know, but we've got 50. That is of the positive tests in your county, Sangamon County, 98.36% survival rate. Of your total population of Sangamon County, 99.97%. We are asking your honor, based upon that, and we've pled enough information to ask this court to move forward with this case on a deck action to say there is no disaster in Sangamon County. That's more than sufficient information to at least continue to gather information this court can analyze and say, yeah, I think there is one. Public health emergency. That's okay if you decide that. Or you might say, no, I don't think there is. Not to accept what they say to you today, citing all kinds of documents and articles and news reports saying you don't even let the clients or defendants continue, Judge. I wonder why they're doing that. I wonder why. I'd like to find out. Again, the governor, in his proclamation, says all 102 counties. We believe that that gives us the right to attack it county by county. We believe we've pled enough facts. We believe the court can take judicial notice of, especially Sangamon County, to say there's a fair question here of whether or not there is a public health emergency by definition, which the governor has to have to wield some amount of emergency power. We'll argue about what that means later. That's not for today. We've gotten that far, Your Honor. We have. We've gotten that far. The issue of the epidemic, we can amend it, because it's not in, I agree, we didn't plead that. It's in this last one. We'll just, again, we'll add 2 words. There's no public health emergency or an epidemic. Well, I guess that's 3 words. And we can continue. But to dismiss this cause of action for reasons that they've asked would be a complete miscarriage of justice. Eliminate, which is really what they're asking to do, is to eliminate this court's discretion and to take away yet the 3rd branch of government in our constitutional setup from having any oversight to any of this, because they want you to just merely accept what they say is true. And we're asking you not to do that.
He said that I primarily spoke to you about fear. He said I primarily argued to you that all you have to do is look at our facts and believe that our facts are right and not the factual allegations that they set forth. And I'm pretty sure I didn't do any of those things when I was up here, Your Honor. I went through our argument and we sum it up again. The first part of our argument is that it's legally irrelevant whether or not there is a disaster in Sangamon County or Clinton or Bond or Richland or any of the others. It's legally irrelevant under the Emergency Management Act whether there's a disaster in those counties to get to the question of whether the governor can exercise emergency management powers in those counties. It is legally irrelevant. That is my first argument. My second argument was that plaintiffs did not plead sufficient facts to justify their conclusion, which this court cannot accept on a Section 2615 or Section 2615 motion. You do not accept conclusions of facts set forth in the complaint. You can only deal with specific factual allegations. That's the standard. And my argument was that they had not pleaded sufficient specific factual allegations to show that this was not a public health emergency in each of their counties. That was my second argument. My third argument was they have not challenged the existence of an epidemic, and I think counsel conceded that that was Correct. So I think there's a little bit of misdirection going on here in Mr. DeVore's response. This is not a case where we are asking you at the motion to dismiss stage to accept our facts and reject their facts. That's not what we have done. That's not what our brief did. That's not what I did up here earlier today.
Correct me if I'm wrong, did you say that plaintiffs have not pled enough facts to show it was not an emergency? Is that what you said?
Not a public health emergency.
Not a public health emergency. And you're saying they have to show that at the pleading stage?
Yes, Your Honor. I mean, the conclusion that they have pled is that COVID-19 is not a public health emergency that exists in their counties. They said that, they said that again. They
So
said
that's
that
a
in their
conclusion, and you say they need facts to support that, okay.
Exactly, Your Honor. I think that's a well-established principle of Illinois law. The standard is not, as Mr. DeVore suggested, did you put your opponent on notice? Rather, it is the question of what facts this court considers on a motion to dismiss, a 2615 motion, like the one that we brought with respect to that argument. Mr. DeVore also spoke to you about your discretion, and I guess I was a little confused about too. There's no discretion when the court is considering whether or not statutory definition has been satisfied, or whether or not a motion to dismiss is legally sound. It's not an exercise of discretion. That's an exercise of applying the plain language of the statute to the factual circumstances either that have been alleged or later on in the case that have been established in evidence. That's not an exercise of discretion. That was a theme that Mr. DeVore kept repeating, and it made me think that his real issue here is with the statute. His real issue here is with the statute. He wants the statute to read in a different way than it actually does. He brings that example of, well, if there's a flood on one side of the state, the governor shouldn't be able to exercise emergency powers on the other side of the state. That seems like a good public policy, right? But he didn't make an argument as to why that is the case under the plain language of the statute. And this court's role, and my role, is not to speculate about what policies would have been preferable, whether this is a good statute or a bad statute. That's for the General Assembly. That's not for the courts. That's not for me. That's not for any of us here in this courtroom. It's for the General Assembly to decide. And the General Assembly did decide, and they passed the Emergency Management Act, which has specific words, specific phrases that were set into law. Mr. DeVore did not speak to you about why any of those words in the text require the outcome that he asked Your Honor to reach. And I think that's because, again, his issue is with the General Assembly. His issue is with the text of the statute. Mr. DeVore also mentioned that the governor has declared that COVID-19 is an epidemic and a public health emergency in all 102 counties in each of his proclamations. That's true. The question is that legally necessary in order to allow him to exercise emergency management powers in each of the 102 counties? I didn't hear him make an argument as to why that was the case. Again, applying the plain language of the statute, not the policies that we think are better than the statute, but the plain language of the statute. I didn't hear that argument. Now, he also read to you from the definition of public health emergency, and I'm sure he didn't mean this to be confusing, but I just want to clear this up in case it was. There are two subparts to that definition, Part A and Part B, and those are, like he said, conjunctive. Each one of them needs to be satisfied. And they conceded that Section A is satisfied, so our focus is solely on Section B, or I should say subsection B. But now within subsection B, there are three possible ways to satisfy subsection B, and those are not conjunctive, those are disjunctive. And we can tell because they are separated by the word or. Plain and ordinary meaning of the word or is that you do not need to satisfy all three of them.
We would stipulate that either one of those three would be sufficient, Your Honor. If I would misled the court, that's not the case. It could be either one of those three.
Well, thank you, Mr. Wright.
You're welcome, sir.
And the reason why I wanted to bring this up is because he read from subsection B1, which speaks to a large number of deaths in the affected population. That's not an argument that we raised in our brief. We focus solely on subsection B3, which spoke to widespread exposure to an infectious or toxic agent that poses a significant risk of substantial future harm to a large number of people in the affected population. That's the one to focus on, Your Honor, not the large number of deaths in subsection B1 or anything in subsection B2. It's subsection B3 that's at issue here. And Mr. Moore also spoke to the first two words that appear in subsection B3, which is widespread exposure. And it seemed to me that he was suggesting that there is no widespread exposure because the test results so far have been, a certain percentage, which he suggested was pretty low. I don't think exposure means that you got it. Exposure means that you are exposed to it. all of us are exposed to it right now because it's here in this county. Exposure does not mean that you get infected. That's not what the word exposure means. And the final thing I want to say about that, Your Honor, is that in speaking about the particular words that are set forth here in subsection B3, Mr. DeBoer said many times, that's a question for Your Honor. And ultimately, of course, it is. But he didn't suggest to you any way that you could get there based on the facts that he's alleged and the words in the statute. He didn't offer you a roadmap. He didn't offer you any arguments about how his allegations satisfy these words that are on something acted. He just said it's a question for you. Well, that's true. Ultimately, it is a question for you. But he's got to make the argument. He can't just stand up here and say, Your Honor, make a decision without giving you an argument about how to get it. That's a basic principle of American jurisprudence. It's a basic principle of Illinois law. He's got to allege in his complaint facts that support his argument, and he's got to come here before you today on a motion to dismiss and explain how those facts are legally sufficient to reach the outcome that he's requested. He did not do that. He did not file a response. He did not do that here today with our argument. For all the reasons set forth in our brief, Your Honor, I respectfully ask that you dismiss these 6 consolidated county cases and deny the motion to add count 5 in Representative Bailey's case.
Thank you. Are you jumping, Mr. DeBoer?
Excuse me?
Are you jumping to say something?
No, I wasn't, but
Okay.
if Your Honor would like me to respond, I can.
Well, they have to respond.
What's that?
Then they have to
No,
respond.
I
If you have something that you think I must know, I will hear it. We are here. I want everything out.
Just merely the issue of under 615, Your Honor. We have alleged facts. The facts are population, total positive test, how many people they tested, how many people have passed away. Those are facts. Is that a facts enough to survive a motion to dismiss? Certainly. Thank you.
Your Honor, I apologize.
I was gonna let you talk since I let him.
I appreciate your indulgence, and I'll be very, very brief. I'll just repeat what I said at the opening, which is that those facts speak to the current conditions. They do not speak to the statutory definition, which is about the risk and probability of future harm. Those facts are insufficient to satisfy the statutory definition. Thank you, Your Honor.
Thanks. All right, counsel, I don't know if you want to confer. I told you I would allow you the opportunity to file a written response if you so desired after the court reporter has transcribed it for you if you want. I don't know if you two want to take a few minutes and talk about it and then let me know. I'll give you some time to talk if you would like, or if you already know.
Your Honor, thank you for the opportunity to respond. I know that you've received a lot of paper from us, and I think we were able to adequately address Mr. DeBoer's arguments here today, so I respectfully decline the opportunity to file a response, and I appreciate the opportunity.
Okay.
Thank you.
All right. I think both sides did a wonderful job, as you always do. I'm always impressed with the arguments that are put forth by both sides. But I do want to consider all this and wrap my head around it. So I'm going to take it under advisement. I always tell you that I will do this as promptly as possible because I do know and I appreciate the urgency of all this. I always welcome proposed orders. That helps speed things up. And, you know, as in the past, I like both sides to see them. I will consider both of them, and then I typically draft my own order from that. So, I don't know if the parties desire to have a deadline to submit proposed orders to me. I will tell you, I will not rule this week. My docket is full. But I promise to get you on as soon as I can.
Your Honor, I can make it work if you need to, but after tomorrow I'll be gone for 2 weeks for vacation, so I'll take my computer with me if you want one, but it's kind of, I don't know what Mr. Particular is doing with that.
We'd like until Wednesday, Your Honor.
that date. So October 21st.
Thank you, Your Honor. Mr. Kincaid reminded me that he's going to be engaged in something over the next couple of days. Can we make it Thursday?
I'll just make it Friday. Is that all right?
That sounds great.
I just know my docket, okay, and so that's not to say I'm not working on it, but,
So a week from Friday.
yes, so Friday, October 23rd.
Thank you, Your Honor.
Mr. DeVore, you can work on the weekend before you leave, unless you leave on
I'll
Friday.
be on the beach on Friday, but I'll send it to you, Judge. I'll be under a cabana with my laptop working on it.
I'm jealous.
Do
Friday,
you want one of both cases, Judge, or just the motion to dismiss?
both,
Okay.
to submit them in Word format. And, anything else then to be addressed today?
No, ma'am.
No, Your Honor.
Okay,
Thank you.
thank you, gentlemen, I appreciate your time and effort, and I, court is in recess.
Thank you, ma'am.
Thank you.